Yes.
May I please, Your Lordship? Your Lordship, I will to mention one unlisted bail application, Your Lordship.
What is the urgency? Anticipatory or regular bail?
Regular bail, Your Lordship.
Tomorrow.
Your Lordship, there is urgency, Your Lordship.
What is the urgency? You are inside already.
Yes, Your Lordship, but the accused person had recently went through operation, Your Lordship.
I will take it tomorrow.
If possible, Your Lordship.
Tomorrow.
Hello, Your Lordship.
Yes. One. We'll have to pass an order. Write it down. This matter is wrongly listed today. List as per earlier order. Yes, next case. You want to mention that time is over? Yes.
Please, Manoj will kindly find page 39 person. Look, person to this complaint by the respondents, by the respondents with regard to allegation of encroachment by the petitioner. So there was claim and counterclaim by petitioner and the respondent with regard to a disputed plot of land. Now, after this complaint, on 7/8/2024, the Deputy Commissioner endorsed the dispute for resolution of the dispute.
Arbitrator.
Yes.
Now arbitrator has taken a decision.
No, it is not the arbitrator who has taken a decision. There is a customary court who has passed a judgment, though there was no proceeding which was initiated before the customary.
So you are not even aware, suddenly you come to know that there is an execution.
There is an execution.
Okay, fine. Now what is the remedy against this judgment?
First, my lord, I am challenging the judgment on the ground of jurisdiction. Because the customary court.
Before that, tell me whether an appellate court is barred to take dismiss and judgment
No, it is not.
on the ground of jurisdiction.
It is not, my lord.
Then,
but with the why I am preferring the CRP, my lord, here, this is a judgment of 18/10/2024. Now, apparently, my lord, there is a 30 days limitation. This judgment has come to my knowledge by when I received the summons in the execution. The execution is pending. Now, your lordship will kindly see page 41 for a moment, my lord. 41, the EAC.
You are not answering my question.
No, I'm answering it.
No,
I'm answering why.
Let us go one by one.
Yes.
What is the remedy against this judgment?
Against this judgment, there is a regular appeal. I can prefer that.
Regular appeal.
Yes.
First question is answered, so you have an alternative remedy.
Yes.
Second question is that an appellate court can also take all points, including point of jurisdiction, in a first appeal.
Yes.
Okay. Now, your difficulty is, since you are not aware of the judgment, already execution has started. And therefore, you have approached this court.
No. Even under 227 also, your lordship has a jurisdiction to entertain this petition because there is apparently a judicial jurisdiction error. First. Second, my lord,
we'll entertain a 227 petition when there is specific provision in the statute. Day before yesterday, there is a judgment from Supreme Court. When there is an appellate jurisdiction, why should we entertain 227?
No, why? But your lordship will kindly appreciate one thing, my lord. Page 43, my lord, will kindly see.
Tell us.
Page 43.
Tell us.
But my answer lies in page 43.
Yeah.
Page 43, my lord. The executive EAC appoints 5 adjudicator for resolution of the dispute. Now, the author of the judgment are not the adjudicator. This is a judgment which is not pursuant to a proceeding which was initiated by page 43. This is a judgment which has been passed at the behest of the respondents behind the back of the petitioner.
Who is the author?
The customary court. The customary court is a civil court within the definition of section.
There is a provision of sending it to arbitrator. Which provision?
No, that arbitration, sending it to the arbitration, that provision has been repealed by amendment by enforcement of the enactment of the 2021 Act, AP Civil Code Act. So now that provision is no more there.
Are you sure?
Yes.
Recent amendment that Universal for the civil code sector, loose six. There is an amendment in 2023. This is very important book in this code.
Regulation निकालो.
Give all this, civil code sector.
Regulation. वाला नहीं पुराना वाला मेरा से वो वाला लोकल एक्स निकालो उसमें है. Regulation 46 was the earlier regulation मतलब for arbitration.
Now, what is the amendment?
Section 27, my lord, will say. First, your lordship will see the AFR, my lord, because the regulation 46.
45 or 46? AFR.
AFR.
Frontier regulation.
38. Regulation 38. And by section 27 of the AP Civil Code, section 38 is deleted.
Regulation?
Regulation 38.
38.
May I pass on this?
37 is deleted.
38.
38 is deleted.
Deleted.
What was the earlier provision?
Earlier 38 was the deputy commissioner and the assistant commissioner shall in every case in which both the parties are indigenous to the tribe endeavor to persuade them to submit to the arbitration by a panchayat. If the parties agrees, each party shall
Now,
nominate an equal number of.
this deletion was when?
This deletion is by the Act of 2021. 12th of April.
When this matter was referred?
This matter was 7/8/2024.
So that should be your case.
No, that this order of 7/8/2024 was appointing 5 adjudicators for mediating. Though the word arbitration has
No,
been
where
used,
is his power to do that?
it cannot be.
So that's it. That's your case.
That's also
Where
my case.
come-
No, that's also my case.
That should be your case.
No, apart from that,
We do not require any apart from that. Our authority is not having a power under the amended act.
Amended
to
act.
refer it to the mediation matter ends there.
Ends.
Anything falls thereafter will fall. Heard. Mr. Swenson, Learned Counsel for the petitioner. By way of the present revision petition, the petitioner has assailed an order dated
the 2/9/2024
2/9/2024.
and the judgment and decree dated 18/10/2024.
2/9/2024. Where is that?
2/9/2024, page 43.
2/9/2024. By which the Executive Magistrate, Itanagar, Arunachal Pradesh, referred the matter to dispute between the petitioners and respondent, private respondents, to arbitrator consisting of 5 arbitrators. Subsequently, the further challenge is an order dated
Judgment dated
18th of October 2024,
page 45.
which was delivered by a customary court. The challenge is twofold. Firstly, that the order of the deputy commissioner, the executive magistrate, dated 2/9/2024, is without jurisdiction in as much as after deletion of regulation 38 of AFR, such authority is not vested with any power to matter the refer to the arbitrator. And the second ground is that though matter was referred to an arbitrator, but the order was passed by two Gaumburas, not by the appointed arbitrators. Full stop. This means matter needs further consideration. Full stop. This more particular further consideration, considering the matter in entirety, more particularly the fact that the power of a executive magistrate to refer a matter to arbitrator since being deleted by the Amendment Act of 2021, is that it? 2008, no? Amendment was
The principal act,
amendment of
the principal act,
principal,
Arunachal Pradesh Civil Code Act 2021.
was deleted. This court is prima facie satisfied that the petitioner shall be protected by an interim order. Accordingly, it is ordered that the impugn ordered at Swensu shall remain suspended till the returnable date.
Order and the judgment.
Yes, both.
Grateful.
Three and four. Not three, no? 3 o'clock.
It is wrongly listed here in the motion stage. It should.
It is wrongly listed in the motion.
It should be in the similar matter, Lordship, in the today's bail hearing, Lordship, 9 onwards.
Okay,
From
we'll take
12
up along with 9. Okay,
Yes,
not
yes.
now.
Right.
Not possible. You keep it, you call along with 9. Scan copy is received in item number 5.
4 and 5, Your Lordship, CD may be called for.
Item number 4 and
No,
5.
item number 4, he is already on interim.
No, Lordship.
No,
So
Lordship.
that first, I have moving this first for the first time, Lordship. 4 is for the anticipatory bail and 5 is for the quashing of that same FIR, Lordship. Both the matters arose of the same FIR. Itanagar PS 203/23. FIR starts at in the anticipatory
I have
bail.
seen that, I have seen that.
Lordship.
Serious allegation of cheating.
No, Lordship, I'm on that point, Lordship. The entire case is based that I have introduced, being a professional CA, the informant is my client. He and along his relatives, I used to provide them the financial services.
When can you appear before the IO?
Lordship, may I submit, Lordship? on-
No, if we give you an interim protection, when can you
As
appear?
an undirected, Lordship. But Lordship, before that, I want to say just few words, Lordship. Because I am no way connected with the bills. I am no way connected with the seller or buyer.
So tell everything to the IO and give documents. Start, Mr. Poddar, learned counsel for the petitioner. This is an application under so and so, so and so. So and so, so and so. 482 of the BNSS seeking anticipatory bail in connection with Itanagar PS case number 0203/2023 under section 420/468/471 IPC. Peruse the material available on record as well as the FIR. Full stop. It is projected by Mr. Poddar that this is the petitioner is no way connected with the alleged offense in as much as he is a professional CA and he advised as in his professional quality, professional capacity. Full stop. This matter needs consideration accordingly.
Your Lordship, the matter may be fixed on 15th. Meanwhile, CD may be called for. If
15th.
1 month, 1 month time, Lordship.
No, Your Lordship,
you have to
since
confirm
Your Lordship will
Calcutta,
see then
Hey,
FIR.
Calcutta, Mr. Poddar, Calcutta will go and come back in the evening
He may,
on 15th.
the matter may be fixed.
Fix on 15th. Call for the scan copies of the case diary on listing it on 15th, considering the nature of allegation and the projection made. It is as an interim measure, it is provided that the petition in the event of arrest, Swenso, petitioner shall be released on bail on the following terms and conditions. One condition will be he will appear before the 15th will be too early because he will come from.
No, Your Lordship, he can appear on 30th because today is 6, 7, 8, 9, 10, 11, 12, 13,
List this matter on 17th.
17th.
Okay. 17th is a working day.
17th is a Saturday, Your Lordship.
Saturday,
16th.
16th. The petitioner shall appear before one of the conditions will appear before the IO within 7 days from today.
Your Lordship, if
to
your
record his statement.
Lordship, if your Lordship is for the condition, your Lordship, at least one of the surety may be local, because this is an FIR of 2023, your
No, no,
Lordship.
we understand.
Yes, yes,
It's a anticipatory will. Local surety will come later on.
yes.
Later on, local surety will come later on. Now, this now criminal petition lists this matter along with AB 64/2025 on
16th.
16th.
You have to serve notice on the respondent too, Lordship.
We are not issuing notice at this.
This privilege.
Let us see the case diary. If you are satisfied, then we will give you ground absolute, then we will consider Quashing.
This privilege.
Huh? 15,000. Five is same. 3 and 4 and 5. 5 you write it down, list along with 20. 6.
Lordship, kindly the matter may be possible for timing because my senior AK Prakash is appearing in court 1.
Where, please?
Yes, Mr. Tama.
My lords, very small issue, my lords.
Sanction. Isn't it?
Sanction. In absence of sanction, whether discharge is permissible under the law or not, my lord. This is the only issue.
Now, where is the provision of yes?
Yes, your lordship. Yes, if in want of sanction, your lordship is entitled for discharge, your lordship. This is the settled law, your lordship. But your lordship, here not only sanction, here protected other provision.
In the process, in the want of sanction.
Yes, your lordship.
What is the procedure? Please tell us. There was an FIR.
Yes, your lordship.
Now, there was a search sheet.
Yes.
Search sheet is filed before.
Actually, before filing of the charge sheet, all the record has to be placed before the concerned sanction authority.
Sanction authority.
Yes, your lordship. And
Now, sanction authority is to give sanction.
yes, your lordship.
Then, or they can file search sheet
Yes,
before the committal magistrate.
yes.
Is that it?
But-
Is there any provision of committal magistrate here? Committal magistrate,
CGM only. your
search
lordship.
with CGM,
Yes.
they can file it before CGM. But CGM
Will not take cognizance.
cannot take
Cognizance.
cognizance.
Yes, your lordship.
Cognizance. Now, this matter is related, order passed by CGM.
Yes, your lordship.
Pass by CG.
CGM.
Order passed by CGM.
Yes, your lordship.
So, CGM cannot take cognizance.
Yes, but cognizance already taken.
But he cannot discharge.
During
Question is,
this
there is a difference between
Yes.
taking of cognizance and discharge.
Yes, your lordship.
He cannot take cognizance. But subsequently, there may be a sanction.
Yes.
When sanction comes,
Comes,
then
yes.
only he can proceed.
Yes,
This is
correct.
not the procedure.
Correct.
That's all.
One more.
So once you discharge a person, this is a discharge.
Hmm.
And for want of sanction, you cannot discharge, but you cannot take cognizance. There is a difference between two.
Yes, yes, absolutely correct, my lord.
So
On
you
not,
are absolutely correct. This discharge will mean all time to come is discharged. We cannot direct the authority to give a sanction. But he can pursue his remedy.
Correct.
Sanction is rightly not given. But
Yes.
once it is discharged, there is no question of sanction.
Correct,
And
lords.
this is the issue.
and your lordship, even if discharged, if it come with the sanction, then court has to take cognizance again, your lordship.
No.
Because discharge is not
Once a
acquittal, your lordship.
discharge, it's a discharge.
It's not an acquittal, your lordship.
Discharge is an acquittal.
No, your lordship, discharge
No,
is
no.
not an acquittal, your lordship.
It's a, see, show us the provision,
Yes, your lordship.
sanction provision of the sanction.
19.
This provision of sanctions are required in different stringent acts and
Yes,
under
sir.
even under IPC. Where question of is of cognizance.
Your lordship, with the Arunachal Pradesh Court, volumes 8, your lordship. Page,
72.
your lordship, 75, your lordship. Provision 149. 149.
Volume 8.
149. Two provisions are there, your lordship, not only regarding sanction, the other aspect is also there. He
Let
cannot,
us, let us,
yes, yes,
generally, I am expressing my opinion on the basis of provisions under CRPC and all.
yes, your lordship. One-
Yes, which provision?
149, my lord. Then I will come to 143, your lordship. Every member, officer or other employee of a Gram Panchayat and Anchal Samiti and a Jila Parishad shall be deemed to be a public servant within the meaning of 21 of IPC.
Okay, fine.
Then 197 comes, Your Lordship.
190.
Yes, now Your Lordship will come to section 143, Your Lordship.
143.
Yes, Your Lordship. Yes, may I read, Your Lordship?
Just a minute.
Okay. Yes. Bar of action against Gram Panchayat, Anchal Samiti or Jila Parishad, etc. and previous notice before institution. No suit or prosecution shall lie against any member, officer, employee or agent of a Gram Panchayat or a Anchal Samiti or a Jila Parishad in respect of anything done or intended to be done in good faith under this act or any rule or bylaw amended thereunder.
No, that is.
Now your lordship may come to the function, your lordship.
So let us go to 143 first.
Okay, Lord.
143 says, in respect of any act done or intent to be done in good faith.
Yes,
Now,
absolutely.
whether it's good faith or not good faith, in discharge of duty, it is under subject
Subject to
matter
trial.
decided by not trial, so far relating to the sanction.
Yes,
The
absolutely.
sanctioning authority.
Absolutely, absolutely.
Sanctioning authority will
Yes, decide.
decide.
Yes.
If somebody is aggrieved by non-grant of sanction, he has some other remedies. Now, what is the other provision?
Your lordship, other provision is the general function, your lordship. Whether they have the authority, Gram Panchayat have the authority to demolish that particular.
No, these are on merit.
Yes, your lordship.
Please let us see what is the allegation.
Forty-two. 42, your lordship. Annexure 10. Forty-four. 44, my lord. The type copy. Married, your lordship. All the accused has been named in the subject, your lordship. And the content.
Anyway, FIR is blocked. We are not concerned with the FIR.
Yes, your lordship.
Because we are not taking note of postment of
Yes,
the FIR or
yes,
charge sheet on
yes.
the ground that no case is made out.
Absolutely.
Here is a case is sanctioned. Now it was charge sheeted.
Yes. Charge sheeted, your lordship, and wrongly, your lordship, if sanction is not there, cognizance has also been taken, and during the CC stage, it was.
Where is the cognizance? Order of cognizance?
Your lordship, order of CC is there, your lordship. That means if CC comes without cognizance, the CC is the, your lordship, the post cognizance.
Scan copies are there. You are for? Ready? Ready?
Seventeenth page, your lordship, impugn order. PCR.
Nothing is in order. How do I look in these pages? Please, Mr. Tama, wait for some time. Pages are sick. Can anybody read like this? Huh? Correct it. Let us finish up the other matters. Wait for some. My lord. We want an order of cognizance.
Yes, I will find
Because
it.
record is there.
Yes, your
We
lordship.
want a cognizance. It cannot proceed to
Yes,
cognizance.
exactly, your
That's
lordship.
all. Forget about others.
Yes,
So
it-
if that is the situation, we'll set aside the order of discharge and we'll leave it as it is.
And cognizance also, your
That's
lordship.
it.
Cognizance as well.
Cognizance
Yes,
also.
yes, yes. Your lordship.
Both will set aside and
Side-
leave as it is.
Yes.
With a liberty to proceed as and when
Sanction comes.
sanction is done.
Yes.
That's all.
Yes.
Mr. Agavar.
Lord, the appeal was admitted, my lord, on 19/12/2024. Reports were called for, reports received. And we said, my lord, that we will given the certified copy, so certified copy we applied, we'll get it, my lord. Now, so far the stay is concerned, my lord, notice was issued, they have filed their reply, we have filed our reply to that. And there is another IA for, my lord, producing additional evidence. In that, order has been passed that it will be heard along with the notice was issued, heard along with the.
Okay.
Now, my lord.
Now, why this matter is
My lord,
listed
I am
today?
basically, my lord, this for, my lord, stay of the proceeding, because in the meantime, my lord, they have filed, my lord, the execution proceeding before the, my lord, the reference court. So that is the difficulty. So, my lord, here the basic question is, my lord, that whether, my lord, the earlier, the entire proceeding was under 1894 Act, that was Land Acquisition Act 1894. Subsequently, in 2014, 1/1/2014, the new act came into force. Now, in this particular case, one of the notifications, both the notification under section 4(6) were issued. Even, my lord, the on 27th of November, my lord, the award was passed. It was sent to the government. Government, my lord, on 4th of January 2012, government, my lord, gave the approval. The approval was communicated, I think, on 13/2, my lord. So, my lord, before the coming into force of the new act,
Everything was over.
everything was offered. And, my lord, your lordship has dealt this matter in the Lido Tea Company and all that, where the relief was granted because the approval was not there
Not
prior
there.
to that.
Yes.
Now, my lord, in this case, in spite of all this, my lord, it was held by the reference court that no, 24(1) we will not apply, 24(1) you will apply, my lord. That is the crux of the whole matter. And, my lord, thereby,
Now, what was the award, earlier award,
earlier award was, my lord, given
in terms of 84 Act?
84 Act, around, my lord, 200 crores.
Now,
That was
what
paid.
happened to that?
That what happened, my lord? My lord, I'm just giving the background of. My lord, it was basically for, it was, my lord, acquired for Reliance Energy Private Limited. I'm sorry, Reliance Energy. They, my lord, did not pay the money. Then, my lord, ultimately the government and we, my lord, the NIPCO, came into an understanding in 2023 that since this project is there, we take up the project. We have a memorandum of understanding between the state government and the NIPCO. Then, my lord, there was a meeting between the landowner and, my lord, the NIPCO and the state government. When, my lord, it has been, my lord, the minutes of the meeting would show that it has been agreed that no fresh proceeding is required. Whatever is there, that there.
No, that is another part. That part is basically whether the new act will be applicable, 2013 Act will be applicable, or 84 Act will be applicable. This aspect, after that Indore Development Authority, na?
Indore Development.
Indore Development Authority, and in Lido too, I have also interpreted when, how, where,
Yes.
what is an award, everything. That is the main crux. Now, there was already an award. There was an amount in that award. Whether that has been paid.
But that has been paid.
That has
There
been
is no
paid. What
dispute.
was the amount?
Around, it was around 200 crores.
And Mr.
Lord,
Patel, you are repairing for whom?
I'm for the landowners.
You are for?
I'm for the landowners,
Landowners. So earlier part is paid to you.
my lord.
There is no dispute on
There's
that.
no dispute.
Now, what we need to stay the subsequent.
What we had prayed, my lord, is that the earlier award, we are not disputing. In 2009 to 2012, there was a proceeding. As per that proceeding, an award was drawn. But then Reliance Industries, my lord, at that point of time for whom the land was acquired, they did not pay the money. And therefore, even though acquisition proceeding was completed, no compensation was paid. The stalemate continued till 2023, when ultimately, my lord, NIPCO and in that particular meeting, I have no objection. They are paid compensation as per the 2013 Act. Thereafter, my lord, the exercise was carried out afresh. The earlier award was of around 107 crores. But now, as per the 2013 Act, 100% solatium was added. And we will pay the money in sometime in 2024.
You have even got benefit
Of
in terms of
2013 Act.
13
Act. What we had said in the reference basically is that since you have already adopted 2013 Act, the rates which were given to us in 2009 ought to have been also revised in this particular award.
So accordingly,
so the market value also has to be updated.
So therefore, it went for a reference.
It went for a reference.
So at this stage, I think they have a case for a stay.
My lord, the stay,
Suppose tomorrow we decide that this is a case where 2013 Act is not applicable. Suppose,
my lord,
assuming 2013 Act is not applicable, there will be again all the judicial process that is going on will become zero. And suppose we held that no, that can proceed, you will definitely be entitled for interest.
15%.
So
15%.
balance, I think, is in staying and deciding the matter immediately.
And we are ready to argue in the June matter can be fixed, everything is
I
ready.
think so. That is the.
my lord, as far as execution is concerned, of course, I also understand that the appeal is pending, we will not proceed. But then as far as if express stay is made, my lord, the question of deposit, my lord, is what
was
I
the,
want to argue.
what is the amount in the execution?
So there around the huh?
330
Around 300
crores.
crores additional amount has been paid. Grant payment.
Beyond 200
Beyond
crores,
200.
300 crores additional amount.
Additional amount. Now my difficulty will be a lot. Will kindly consider one aspect of the matter. These are the village people.
No, they will understand. You will say that I will deposit. Tomorrow I will win the case. I cannot recover it. We understand.
My lord. And then in all land acquisition cases, my lord, mostly deposits are made.
That we understand. But apparently in this case, subject to what he has argued, if award was approved before the act came into effect,
My lord.
subject to further deliberation and all,
My
we are not concluding anything. I think we should finish up the entire matter.
That will be the
At the earliest.
Definitely.
At the
That will be the
Even-
best
even-
For
even-
the earliest, until then, execution remains still without deposit.
My lord, that might be difficult, my lord.
How much amount will you want them? But even if it is, we pass a direction, no release.
Instead of doing
that
Lordship rightly saying, my lord, that the matter can be had, my lord. We are ready
Yes.
to argue the matter in June, my lord. Your lordship can pick the matter, we'll argue the matter, finish it, my lord. Because the basic question is, my lord, 24
Respect. It is not a case that you have not been paid a single penny.
Definitely.
So you have been paid a substantial amount, maybe hundreds or 200, 500 people,
My lord.
but 200 and odd crores are paid. Now remains is another 300 crore.
My lord.
And then substantial issue is there.
My lord.
And it is also a fact that if we allow to pay it to you,
My lord.
there may be difficulty in recovery. This is one.
Definitely.
Even if we say that deposit in these courts, that will be an ideal money
Ideal
pending in the court. Better
They will
let
be
them
loser.
invest and
They will be
develop
loser.
the
In that
nation.
circumstances, they will be losers.
I think this will be the balance order.
My lord, what I would suggest that since we are anyways going for a final hearing, the records, otherwise certified copies, we are also due to collect today. It has been prepared. Let it come up thereafter, my lord, because it might, before even a stay is granted, my lord, I think it would be better to go a little bit deeper. We have projected the facts in a very superficial manner as of now, because there are aspects as to why
So you say
why the 2013 Act is
you
applicable.
say that
Because there is a concession from their side that
you say that we are not at this point insisting on the
we are not insisting.
execution process,
We are not insisting.
provided matter will be decided at the earliest and no
Right.
adjournment will be taken.
Well, yes.
That's all.
That's all.
Well, even I am ready today, but
I have some
matter of fact, he is
personal-
not ready, I know.
personal
Because,
difficulty
Lord,
today.
we have not picked the matter for hearing.
Okay. Heard. Mr. Agarwal, learned senior advocate, assisted by Mr. Senapati, learned counsel, and Mr. Pathak, learned counsel for the opposite party appellant.
State collector is also part.
Huh?
Collector is also part.
And Mr. For
72.
respondent number
73.
72. The connected LA Appeal 2/2024 revolves around a dispute whether the land acquisition in question shall cover by the Act of 1884
1894.
or
94.
94 and or whether it should be award should be passed in terms of the Act 2013. It is also on record that certain the compensation determined in terms of 1890 Act 1894 has already been paid to the affected persons. And the execution proceeding is pending for execution of subsequent award which
In the,
In enhanced award.
by the reference code.
by the reference code in terms of the 2013 Act. Mr. Pat, accordingly, Mr. Agarwal has insisted on stay of the execution proceeding in question. Mr. Pathak, on the other hand, in his usual fairness, submits that since appeal is pending, they will not pursue the execution proceeding as at present. However, matter should be heard at the earliest, and the appellant could not delay the matter by taking unnecessary adjournments. In view of the aforesaid consensus, list this matter
16th of May Lord, 2 days later, 16th and 17th of May Lord, June.
in 16th,
And
where,
17th.
Mr. Pathak,
My lord,
16th and 17th June.
2 days would be well.
Okay, list
If
this
need be,
matter
we'll
on
continue.
on 16th of June, and if necessary, it may be taken up on
Monday, man.
on day-to-day basis. Full stop. Taking note of the submission of Mr. Pathak that they will not pursue the execution, this court has restrained itself from passing any interim order.
My Lord, your Lordship is passing this order in the main LA, my Lord, or
In LA or IA?
let it be in
In
the LA.
the LA, I am
LA,
passing,
it-
IA still remains, we are not
Ah.
closing it.
My lord.
Both the IA will be listed along with that.
Okay.
Huh?
List this matter along with, where is the, there is some other matter listed in this today's list?
My Lord, item 23, my Lord.
Some other matters are listed.
Yes, my Lord, 23.
What is this?
Well, that matter is, my Lord, what happened in this case? My Lord,
It is not related to Mr.
it is
Pathak.
not related.
I'm not. in.
Okay, then it is,
Not
list this matter along with that automatically, list accordingly.
My Lord, the other matter. Other matter is there.
Different issue. Different, we'll come back to that. We'll come back. I thought this is similar.
No, not similar, but arising out of the same.
We'll come
Arising
back
out
to
of the
this
same.
at later part. Yes.
Question, record question. My Lord, your Lordship will kindly also, they will file an application before the executing court.
No, that we have,
No,
that's all. That order will sufficient. I do not think somebody. No. Yes,
Well, here the issue is,
return.
it cannot, it's also said as return, my lord, because that an application under order 7, rule 11. Now the learned district judge, one hand says that yes, I have a jurisdiction to decide this petition, but given the facts and circumstances of this case, as there is an appeal also pending before the civil judge, and that appeal was declared to be infructuous in a different court, and the parties were asked to go to the village authority. Now the issue where lies, my lord,
This is the difficulty. Why we would come straight to the High Court?
no, because see, my lord will kindly say that this is not an order under order 7 rule 11. Had it been so, I would have,
What is the application?
application was order 7 rule 11, the plaint is not rejected.
Plain is.
Not rejected.
It is returned.
Return saying that I have a jurisdiction, because order 7 rule 10 court has to say I don't have jurisdiction, therefore it is returned. It is not saying that it is returned. Both the parties should go to the village authority. There was already an order passed by the village authority in a conflicting petition, wherein their appeal is pending before the civil judge. That appeal was declared to be infructuous.
Who declared that?
The Lorry district judge. Very interesting order. Your lordship will kindly see the order first.
Yes, what you want to say?
Your lordship, this order, the impugn order was passed, holding that your lordship, since the divorce was sought on the customary law, on the basis of customary law. So the simple thing was that the authority which is recognized by the custom
and usage of the parties should be the appropriate authority who will take up the matter, because it is unlike the other Hindu Marriage Act where exclusive jurisdiction is given to the district judge, or Special Marriage Act, exclusive jurisdiction is exercised by the district judge. This is the matter where the party has come, petitioner herein has come under the custom and usage of Adi customary law. If that custom and usage is,
Where is that application?
that is at
The divorce petition, my lord, will find at page 19.
page 21 is the relevant.
No, that's a introduction that the parties
No, it is subject matter is divorce.
divorce.
Now, subject matter is divorce. Between whom?
Between the petitioner and the
Hindu,
no,
Muslim,
no,
Christian?
no. Had it been so, the personal laws would have governed. Now, my lord, the question here is.
So the question will come
My
later.
lord,
Please answer our question
Yes.
first. There is, when there is a personal law, divorce is under the law, say in
under the
a
personal.
Hindu Marriage Act,
Or-
divorce is before this court or a special court. In Christian Marriage Act, it is somewhere else, so on and so forth. Now, you will have to, where is that provision under section 9 or section 151, order 22, rule 22A of the Civil Procedure Code, giving a jurisdiction to the district court to decide a divorce dispute. Where is that?
My lord, the personal law, Hindu Marriage Act, Special Marriage Act, and Divorce Act confers clearly a jurisdiction to the district. Similarly, in the Muslim,
Forget
Yes.
about others.
yeah, there the court is not say. Therefore, it is a declaratory suit. It is suit for declaration of dissolution of marriage.
So
If
where
that-
it will like at the first instance, district judge is not having.
No,
original
that is one. That is one limb of argument I was thinking of making it. That if the court comes to a conclusion that as per section 15 of the CPC, it is to be before the lowest court, then the customary court and civil judge senior division are the court which exercise parallel jurisdiction.
No,
Yes.
sorry. Here are, you have two options.
Yes,
If-
that is
if-
what.
if you
That is
are-
a preferential jurisdiction.
Preferential.
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 I'm sorry.
Ah.
Preferential jurisdiction. Why? Because the customary court is defined to be a civil court.
See, don't go to all this. In Register General's case, are you aware of that?
Yes, yes.
In Register General case, it is specifically made clear by the division bench that so far relating to the northeastern states, their right to go to customary courts still remain, even if still remain, and as per the scheme of the Constitution of India, the Civil Courts Act is to be bring into. Okay, so therefore, finally, Register General it says that civil court will also have
Have
jurisdiction
jurisdiction as well as customary.
customary.
That was my
Now, except for the criminal proceeding.
except for
Now, therefore, you have two options. Either
to customary court.
to go to customary court or to file a declaratory suit until and unless you claim to be Hindu or Muslim or Christian, to go to the civil judge, junior division or senior division, whatsoever.
Based on the
Okay, that is the original code. District judge by stress of no imagination, either under Civil Courts Act or under customary, or that this is what is called frontier regulation, by stress of no imagination having any jurisdiction for to entertain your case. That being so, if the district judge has said, go to customary court, we may interfere with that, giving liberty to the person to approach the appropriate forum.
My lord, in fact, my argument before the district judge was that the customary court and the civil court will have both have jurisdiction.
So
But
where do you want to go?
no, one argument was that as per the AP civil code, the district judge is also a original civil court. it has been conferred the power of an original civil. Now, if we invoke section 15, that it would be a lower court, then based on this pecuniary jurisdiction, because civil court junior division has got a pecuniary jurisdiction, like customary court has got no pecuniary. Similarly, the civil judge senior division has got no pecuniary jurisdiction. In such case, the district judge ought to have been correct if the district judge ought to have returned the petition, allowing the parties to file it before the civil judge senior division. But that is not been done. On the contrary, the
You don't want to go to the customer.
customary.
That's all.
Yes.
So
And in fact, there is one order. The respondent, while after the institution of the divorce proceeding, they instituted a proceeding before the customary court for restitution of the rights, cohabitation, restitution of conjugal rights, which was ordered against me. I was directed to cohabit, and there is a very peculiar order where I have been said that if I don't go, I will be not entitled for any maintenance allowance. That order was appealed before the learned civil judge as per section 15 of the Civil Code Act. Appeal lies before the civil judge. That was under stay. Now, the learned district judge, while passing this order,
he cannot
interferes with that
exceed
order.
his jurisdiction to comment anything on that.
Absolutely. That is what my case is.
That he cannot comment on this.
If your lordship clarifies that it is the customary court and the civil court will have preferential jurisdiction, it is left open to the parties to decide which court they choose. Now, end of the matter. That is what
Your Lordship, my line of argument is that, Your Lordship, what I am submitting here is that the party, if we see page 22, where the specific averment has been made in the divorce petition, it is very much clear that the party is seeking divorce under the customary law of Adi indigenous tribe, Your Lordship. Now, Your Lordship, we have to see, Your Lordship, why APCC has classified.
Where is that statement?
That is page number 22, Your Lordship.
Page number
22 of the petition. This is the annexer 1, and this is the relevant portion of the divorce petition, Your Lordship. Para 3, Your Lordship.
Para 3 of the divorce petition.
Divorce page number 20.
19. It starts at 19.
19 it is, and relevant portion is page 20.
Page 21, paragraph 1.
Yes.
So page 22. Para 3, the present petition is filed under section 9, read with section 151, order 32A of CPC. Despite the absence of formal matrimonial legislation governing the parties, they are bound by the ancient customary law of their indigenous.
Where is that?
Page 22, para number 3.
Para 22.
Yes, sir. Page 22, para 3. The present petition is filed under section 9, read with section 151, order so and so. Despite the absence of formal matrimonial legislation governing the parties, they are bound by the ancient customary law of their indigenous tribe. Under their customary law, cruelty and neglect are recognized as grounds for divorce, among other reasons. While these tribal customs have not been formally codified or legislated, the community members have consistently adhered to them in resolving civil disputes. So, Your Lordship, from this particular portion, it is very much clear that they are seeking divorce under the tribal customary law.
No. They are saying we are tribals of this.
Yes.
But in terms of the judgment of Registrar General, they are having right, even if you are tribal, both are tribal, either to go to customary court or to go to the civil court.
Even, my lord,
Based on that ground only, Your Lordship, because
no, that is not a ground. That is the declaration as regards their status.
Yes,
and it is not the law that moment they are tribal and follows customary procedures of marriage and all, will mean that they are barred from approaching civil court.
Obviously, Your Lordship, they are not barred. But Your Lordship.
So if they are not barred, the best thing the district judge could have said that I don't have jurisdiction. Please go to the appropriate forum, either to the civil court or to the customary court. That's all.
Yes, Your Lordship. Only to that effect we are conceding, Your Lordship.
But what about what is the power of the district judge?
Yes.
By whatsoever exercise of power is without an appeal having a right to close a pending proceeding?
Your Lordship, it was just in an advisory observation it was given, Your Lordship. This is the relevant portion was there in the
judgment.
Page 126 is the judgment.
And
My lord will find
134
page 134.
Heard the learned counsel for the parties. Heard Mr. Swenso, and Swenso. The present application is filed assailing an judgment and order dated 28/2024. Passed in IA 06/2024 in divorce suit number 04/2024. Full stop. The brief fact leading to the filing of the present case is that divorce suit number 04/2024 was filed by the petitioner against her husband respondent herein for dissolution of the marriage between them and permanent alimony of 25 lakhs with a further prayer for custody of minor daughter until her majority and an interim maintenance of 15,000 only in addition to the alimony being paid, alimony granted, alimony of rupees 20,000 granted by learned Chief Judicial Magistrate Pasighat. In the proceeding, the respondent husband filed an application, interlocutory application, registered as IA number 06/24 under Order 7, Rule 11 of the Code of read with Section 151 of the Code of Civil Procedure with a prayer to reject the divorce petition number 4/2024 on the ground that suit is barred by law. The impugned order was passed in the aforesaid IA. Impugned order dated 20/08/2024 was passed in the aforesaid IA, whereby the suit was returned to the plaintiff to approach before the customary court to address her grievances to ensure the object laid down under Section 50 of CPC read with Section 18 of the Arunachal Pradesh Civil Courts Act. Though the order is challenged on different grounds, where is that observation?
Page 134, para 21.
Huh?
Page 134,
First
para 21.
Before that, just the degree. Para
21.
It has to be read from para 19, Your Lordship. Page 134.
It was also observed that as in the meantime, the husband approached the customary court seeking restitution of conjugal right, and as the same was granted in favor of the respondent husband, the suit of filed by the wife is required to be tried by the customary court. Where is that paragraph?
Paragraph 21.
As regards pendency of the appeal, appeal preferred by the petitioner wife against the decision of the customary court in favor of the respondent husband, pending before the learned civil judge senior division, this court observed that said proceeding may be withdrawn by the may be withdrawn and treated as infructuous on presentation of divorce suit by the present petitioner before the customary court. And customary court giving the respondent husband to press his application for conjugal right before the customary court. In the considered full stop. It is correct that in terms of the determination made in Register General versus Swenso, the division bench in no ambiguity held that so far relating to the civil disputes, the indigenous tribal people, if both parties are indigenous tribal, has a liberty either to approach a customary court or to approach the regular civil court. Inasmuch as in terms of AFR as well as Arunachal Pradesh Civil Courts Act
2021.
Certain jurisdictions has been conferred appellate as well as original upon the civil courts to take the against order passed by the customary courts. Full stop. This court is of the opinion that when the petitioner and respondent admittedly from Adi community and they follows the customary practice and tradition, and that admittedly there is no codified personal law or personal law seeking divorce, in the backdrop of determination made by the Register General within bracket Supra, the petitioner and the respondent shall be at liberty to approach the customary court in terms of the regulation and customary court or to the regular civil court. It is true that the district judge will have no such jurisdiction to entertain a divorce petition. Therefore, when the district judge admittedly lacks jurisdiction, it was the course of action remain open for the district judge is to return the suit to the plaintiff, giving him liberty to approach the appropriate forum as determined in the case of Register General Supra. Full stop. The learned counsel for the both the parties also agrees that this course of action would be the best course of action as on date also. Now, accordingly, it is taking note of the aforesaid submission as well as taking note of the legal proposition as discussed herein above, the impugned order stands set aside. Impugned sender stands set aside, and the petitioners / plaintiff is given a liberty to approach appropriate forum, i.e. either the customary court or the regular civil court for seeking divorce. Seeking declaration of divorce. Full stop. Now coming to the observation as regards closure of the other proceeding pending before the learned civil judge senior division. That is the
May I indicate this number? Civil
civil-
appeal,
being civil appeal number. As regards the pendency of civil appeal number
civil appeal within bracket Kebang number
Kebang
9
number.
of 24
9 of 2024 pending before the learned civil judge senior division
at Pasighat.
at Pasighat. The learned district judge has exceeded its jurisdiction by closing, by declaring the said aforesaid matter to be infructuous and directing the matter to be taken up by customary court, inasmuch as the issue was already decided by a customary court and was taken to appeal by the husband in terms
wife.
of by the wife in terms of
Section 15,
section 15 of Frontier Regulation, isn't it?
APCB.
AP Civil Courts Act. Therefore, the aforesaid order, part of the judgment also stands set aside, and it is provided that the learned civil judge senior division shall take a decision on its own merit without being influenced by the order of the order of the learned district judge, East Siang District, Pasighat, Arunachal Pradesh.
Your lordship, that liberty to move for divorce proceeding may be given to both the parties here.
Both the parties. No, we need not give because this is his case.
Yes,
Fine.
sir. Okay.
I have said that they are at liberty to approach. Give the citation of registered general.
Deeply.
Dispose of. Item.
My lord, although this is application, my lord, for quashing of the trial proceeding, my lord, that is being,
Joint or
it is not the joint, my lord.
who is representing the other party?
Other,
Informant.
other party, they,
Respondent number.
my lord, they have not made the party, my lord.
They are necessary, more particularly after coming of BNSS.
Yes,
Yeah.
your lordship, but as per this affidavit, your lordship, they want file an affidavit wherein the wife has stated that he died, your lordship. My lord, the victim.
He died.
The
Victim died.
affidavit they have filed, your lordship.
Complainant, no, there is
Complainant.
no victim as such, my lord. My lord, the complainant, my lord, he has deposed before the court, trial court, that there is no commission of the offense as alleged, my lord. The allegation in the FIR, my lord, was that the applicant, the
So
petitioner here.
search sheet was filed.
Yes, my lord. And trial has begun, my lord.
Began,
Even the
evidence of the victim was taken.
my lord.
Now victim said what?
No, my lord, my statement will come to the statement of the victim, my lord.
No, what is the statement of the victim?
His statement is that, my lord, he had never filed any affair against the petitioner. Some 3 local guy, they came to his shop and
Demanded.
forced him to sign a paper, my lord, without allowing him to read the contents of the paper.
Okay.
So that is the deposition of the complainant before the trial
So
court.
there is nothing against you.
Yes, my lord.
There is nothing
Now,
against.
why you have come here?
Because my lord, since my lord, he has already deposed, he has the evidence of the complaint.
No,
has been taken, my lord.
then they will file an application in view of this opposite. I am entitled for discharge.
Yeah.
Why should we exercise our jurisdiction?
My lord, thereafter, my lord, after his evidence was taken, my lord, the complainant died, my lord. Thereafter, my lord, there is an agreement, my lord.
Hope
Mr.
you believe that you people have not killed him.
My lord, no, my lord.
Okay.
Never, my lord. Never.
Arms act is there, your lordship. This issue, yes.
So not only him, my lord.
Who are the other witnesses?
Other witnesses also, they have given their statement. in
How
the
many
trial.
witnesses were there?
There are, my lord, 7 witnesses, my lord. Out
How many examined?
till the 3 witnesses, my lord. No witnesses has reported anything against me, my
So
lord.
why have you come here?
My lord, just for quashing of the trial, my lord.
We don't quash like this.
Yes.
So in the midst of a trial, no evidence to come to High Court and burden the High Court. Is it a process? You are have no. I think I should go to High Court. I'll dismiss this petition.
My lord, not.
And any observation will go against him. Go and face the trial.
Yes, your lordship.
What is the difficulty in facing the trial? Tell us. Please this method next week.
Much obliged.
Too much dismissal. Why rush to the High Court? You have a good case, go there. Even you can file an application. You make a submission. See, these are the evidence why you should proceed further. Court can in the midst of that say that this is the evidence complaint and has died no necessary.
My lord, in this case, my lord, if the I.
We are not. If I'll have to pass an order. I'll say that this is unnecessary petition filed before dismissed.
Oblige, your lordship.
Obliged, my lord.
Item. Yes.
This is an appeal under order 43 rule 1R. On the last date, my lord heard this matter.
Yes. Who is appearing for whom?
Lordship, I am for the respondent number 1, 2, and 4 for the tourism.
You are for
3 and 4.
Tourism.
Lordship, I am for the tourism.
And what you say?
Lordship, for producing all the records, Lordship, the staying council for the tourism and para needs some more time to take some further instruction from the
To take further.
instruction, Lordship.
What is the impugn order?
My lord, the impugn order is page 171. In fact, what I was proposing.
Where is the earlier order? Where injunction was there?
My lord, the first injunction order was 711. Page that your lordship will find, page 63.
Page 63.
Page 63. Page 60, it starts from page 61. Operating portion, page 63. And
Okay,
which
then
which-
what happened?
which stood modified by an application filed by them,
168.
page 117.
117.
117. The modification is page 119, last paragraph.
Any three privacy agent. Other passenger children. So till one after 2 you have to think over. Okay. Page 117.
117 is the order of modification in their application for modification, where they ask for allowing them to use the premises for 4 days. We conceded to that prayer, and thereafter The issue was that we did not, the lessee did never got the possession, and therefore 119, my lord, the learned trial court restrained handing over possession of the property until further order. Now, based on this development, an injunction application, fresh injunction application was filed. Now, that injunction application was rejected.
However, it is made clear that petitioner shall at liberty to undertake any activities. That is their application, is that it?
That is their application.
Their application, however, a transfer of property and alienating the property shall not be done till further order.
Till further order.
Now, in the meantime, alienated
No, it is not alienated. I filed an application
for amendment.
As well as a fresh injunction application. Because this was until further orders.
Now, amendment is allowed.
Amendment is allowed.
Now, where is the injunction?
My lord, page 171 is the order. Here, my lord, to find first portion is the allowing amendment 172. IA 34 was then disposed of. That is amendment. Page 172. Just above the bold letter, IA 32. In view of the above, the petitioner is hereby allowed to amend its pleading only with regard to leasing of the civil property in its apartment made in so and so, so and so. Now, subsequently, this is a common order passed in 3 missed cases. My injunction application was dismissed as hard infractions.
Heard. Mr. Kaushik, learned counsel for the petitioner, also heard Mr.
Your Lord, yes, sir, on behalf of the sitting council.
And Swenso. Who is 3 and 4? Okay, 3 and 4. The petitioner, the present application is filed. Just look into it under section
Order 43, Rule 1.
or Order 43, Rule 1R against an order dated
3/4/2025.
3/4/2025 passed by the learned trial court, whereby the fresh injunction application filed by the petitioner was dismissed with a liberty to the plaintiff to file a fresh injunction petition.
No.
You see, therefore the instant miscase
yes,
has
after
been dismissed and disposed of. However, petitioner plaintiff can file
Yes,
a
yes.
fresh application after amendment.
After
of the
amendment.
After amendment of the plaintiff. The brief litigational history is that the petitioner filed a civil suit registered as title suit number 17/2024 2023, seeking declaration and cancellation of a gift deed dated 15/6/2016, recovery of possession and of main profit MES/NE, and grant of permanent injunction restraining the defendants, their agents, or any person claiming under them from alienating, transferring and leasing out the scheduled property, as well as changing the nature and character of the suit. Along with the aforesaid along with the suit, the plaintiff also filed an application under Order 39, Rule 1 and 2, which was registered as
Miscase
number 19 of
25 of 2023.
Where do we get that? 25 of 2023.
Page 174.
The learned trial court, by an order dated 27/3/2024, after elaborate discussion, no, where is the order dated 7/11?
7/11, page 63. Page 61.
First is
First is 7/11.
Page
61.
Application under Order 39, Rule 1 and 2, page
61.
Order 1 and 2. Passed an order which was registered as IA 39 of 2023. Okay. The London Trial Court below, by an order dated 7/11/2023, after elaborately discussing the materials, directed all the defendants to maintain self status quo as on status quo in respect of the property in question. Property in question. That is within bracket a convention center at 0 till returnable debt. Subsequently, where is that subsequent? Why this miscase was filed?
Page 117, the order.
Page 117. Subsequently, the defendant referred an application which was registered as miscase number
41 of 2024.
Where is that page?
117.
117. Referred an application which was registered as miscase number 41 of 2024, whereby the defendant prayed for allowing them to utilize the aforesaid convention center for the purpose of
Zero Music Festival.
For the purpose of Zero
Festival of Music.
Zero Festival of Music. Such application, the plaintiff did not objected to such prayer. Accordingly, the aforesaid prayer was allowed to use the convention center during Zero Festival of Music 2024 with effect from 26/9/2024 to 29/9/2024. However, it was made clear that petitioner shall be at liberty. However, it was made clear that the defendants shall not transfer or alienate the property until further order. In the during pendency of the aforesaid proceeding, the plaintiff filed an amended petition, filed an application for amendment of plain as the defendant took a stand that
Lease deed is executed. Lease deed is executed.
Stand that the aforesaid convention center has been leased out to one entity.
Defend number 6.
Accordingly, miscase number 25.
IA 34 of 2024. Amendment application.
IA
34 of 2024.
34 of 2024 was registered, which was allowed by the learned trial court by its order dated 19/9.
3/4/2025.
3/4/2025. After where is the what is 19/9?
19/9 is the modification order.
19/9 that modification order we have already recorded.
Recorded. Pursuant to that modification order, we filed this.
This is 34. The IA 34
was amendment.
Was allowed by an order dated 3/4/2025.
It was a common order in all miscases.
Okay, 3/4. It is recorded herein that along with the amendment petition, the petitioner has also filed, the plaintiff had also filed an application, fresh application under Order 39, Rule 1 and 2, which was registered as
miscase number 43 of 2024.
Miscase number 43 of 2024. With the background fact that since lease deed has been executed, the property should not be handed over. Such lease deed should not be given effect to. Though the learned trial court by its order dated 3/4/2025 allowed the amendment petition, however, dismissed the injunction petition on the ground that until and unless amendment is carried out, no such application can be entertained, and however, liberty was granted to the applicant to file a fresh application. Being aggrieved, the present application is filed with an apprehension that in view of rejection, dismissal of such prayer, the lease date may be executed. The lease date may be executed and property may be handed over to the lessee.
Lease deed may be given effect.
Lease deed may be given effect to. This court is also of the considered opinion that in view of the earlier orders, such apprehension is having no base. Inasmuch as there is a specific order already there as recorded herein above, the status quo in respect of the property shall be maintained. Inasmuch as the status quo shall definitely mean that the property cannot be handed over subsequent to passing over of the said property to any third parties. Therefore, with the aforesaid observation, this petition stands closed with a liberty as given by the petitioner to file any fresh application if so advised.
But the order that was modified, that this application has been also disposed by this order. So that order of modification says until further order. By the same order, that application has also been disposed.
So therefore, we have made that is
Or your lordships may say
see
that the
subsequent order is only for a purpose that we want to use for a zero festival. You have considered that order was given. So until further order was not necessary in that case. So that is only for a time gap. Already you have a status quo in your favor.
But initial status quo was not to lease out. Subsequent modification, that 99 order.
That modification is nowhere related to the first order.
No, it is related.
No, because you
why your lordship will say 99 order, the code
we
below
have
to
clarified it is further provided that till such application is the petitioner may file a fresh application within a period of
1 week.
Within a period of 1 week before the learned trial court bureau, seeking file an application under order 39 rule 1 and 2 in the same circumstances and same be considered as per law till such application is
disposed
considered. The status quo in respect of the property we maintain. However, it is made clear that this order will continue, shall not continue in the event no application is filed within a week.
Right.
Now go and fight on IA. FAO stands disposed of. In view of order passed in FAO, IA stands.
Great. Highly agree.
What is this bail applications? And there are some item number 9, something like that.
No, item number 3 was 3.
Item number
only listed in the 3 motion item.
Motion 3.
Item number.
Case that is there.
Yes, Lordship.
What are these cases?
My lord, please, may I?
Are you ready?
Yes, my lord.
Yes. It is a single affair.
Yes,
Rising out of single FIR, my
So
lord.
let us see one affair.
Yes, my lord.
I am taking up any interim order.
Yes, my lord. The interim was granted on 25th of April.
Where is the
accordingly-
affair? I am taking up item number 12.
Yes, Lordship. Lordship, FIR is at page number 15. Type copy is at page number 17, Lordship.
17?
14, yes. 70 is type copy, Lordship.
2 FIR, my lord. First FIR is being filed by the accused applicant here, and counter FIR wherein we are.
Just a minute. Let us please understand what is the allegation against you. Then we'll go to what is your allegation against them. Is that it?
Yes.
Who lost the first affair?
Pardon, my lord.
Who lost the first affair? You
They-
lost
Yes, my lord.
or they lost?
I have lost the
Okay.
first FIR.
This FIR at page 18 is lost by you or them?
FIR at page
18.
17, 18.
It's lost by me, my lord.
Okay, let us see.
Can we see a type copy is at page number 17, my lord?
Just a minute, just tell me. Forcefully entered the land of the victims with loaded guns and machete local down. These are the accused persons. Now, what happened to this accused person?
So based on this FIR, my lord, altogether 22 accused has been
Arrested.
registered, a case registered against 22 of them. All of them have been enlarged on anticipatory bail by this honorable court. So
Where is that order?
uh,
So your counter, who attacked you, they have been released on bail.
so after releasing them on bail, on 29, they have lodged a counter FIR against those present applicant accused person. So from the incident, out of 10,
Where is the affair now against you?
against me is lordship at the phase number 20, my lord, annexure 2. Your lordship will find a written FIR at phase number 23.
Give me the type copy. Where is the type
Type
copy?
copy is at notice 23, lordship.
23.
Yes. 23 onward, lordship.
I am taking up lordship bail application number 52, and in my FIR it is at page number 29, my lord, type copy, page 29.
Yes. Oh, yes.
So basically it is a fight for an agricultural land.
Yes, my lord.
Civil dispute.
One is something. First, they have attacked you.
Yes, my lord. They have attacked me. Altogether 10 members family were engaging in agriculture work, and they suddenly attack and open
So
fire.
you have lost an affair.
Yes, my lord.
They were arrested.
They were
They were released on bail.
They were released on bail.
Thereafter, they filed this affair.
Yes, my lord.
Now, what happened to your bail? That is made absolute or interim?
Yes, made
Yes,
absolute.
my lord.
Where is the given order?
Website, my lord, I have obtained, downloaded it.
So,
Lordship.
they have filed. Let them
Lordship,
fight once again.
I always objected the bail application.
But they have been granted.
Lordship,
Here also will object and will record your objection.
besides lordship, since the interim was granted, so I have duly complied. I have given my
See,
statement.
I'll tell you.
Yes.
They will fight again.
Yes.
They will again come back to this. Why don't you go to the customary court?
Lordship, as per the status report of IR, there is possibility of committing the same offense, lordship.
Rather, lordship,
And they are not cooperating, lordship. Some weapon used by the accused just to be seized, lordship.
lordship, rather, out of this incident, altogether 6 of the accused applicant has sustained a gunshot injury. And
Heart.
none of
See, I will pass this other.
Yes.
Heart, you are Mr.
vitamin.
Everywhere it will be same order. Okay. From 3 to
From 3 to 12 to 20. Altogether 10
just give the
applications.
list. We are Mr. Tamin,
Yes, my lord.
Learned Counsel Court of Petition, accused petitioner. Also Hart, Mr. Swenso, Learned Public Prosecutor. The present application under section 482 BNSS/2023 praying for privilege of pre-arrest bail to the accused appellant, namely, just give the name, in connection with Palin PS case number 09/2025 under section 109 within bracket 1/118 within bracket 2/3 within bracket 5 IPC read with BNS read with section 27 within bracket of Arms Act 1958. Full stop. Considering no full stop before that. From the come on. It is the allegation in the affair that the present petitioner along with some others attacked the informant and their groups and severely injured them. And they also use local guns and
Local
machete.
message.
Huh?
Yes, message, local message.
Message. It is on record that on the same incident, the informant group has also lodged an FIR which was registered as the present petitioners and their group had also lodged an FIR arising out of the same incident before the Palin police station, which was registered as Palin PS case number 08-2025, registered under section 109 within bracket 1/118 within bracket 2/3 within bracket 5 of BNS 2023, read with section 27(1) of the Arms Act 1959. Full stop. In the aforesaid affair, which is part of record, it is disclosed that it is the allegation of the present petitioners that the informant group had attacked them with guns and machete. Full stop. From the material available on record, it is also seen that the dispute revolves around this dispute revolves as regards cultivating over an agricultural plot of land which both the parties claim. First of all, the informant of the present case who were accused in Palin PS case number 08 of 2025, 09 of 2025,
under same charges section.
Approached this court by filing different anticipatory bail application such as AB 48-2025, AB 40-2025, 38-2025, 49-2025, 48-2025, approached this court, and this court under its order, different order passed on 9/4/2025, granted privilege of anticipatory bail to the petitioners, to the informants, to the informants of the present case. It is also seen that the present accused petitioners accused were the first to lodge the FIR. This court, taking note of the aforesaid fact, granted an interim protection to the petitioners under its order dated 25/4/2020, all cases?
In all cases.
25/4/2025. From the case diary, have you record the statement?
Yes, my lord. My lord, out of 10 applicant, 9 of them has record only my lord AB number 60, who is still under critical condition in the hospital. 9 of us recorded, my lord.
Okay. Considering the matter in entirety, the materials available on record, and the dispute and the earlier litigation, this court is of the view that custodial interrogation of the petitioner may not be necessary. Accordingly, the present bail application stands allowed with the following terms and conditions. They will not hamper and temper. They will not indulge themselves in similar act. Third, they will cooperate with the investigating authority and get their statements recorded. First up, finally, with all these conditions you give, finally, the petitioners, the IO shall be it is needless to say that IO shall be at liberty to seek for recall of this order in the event the petitioner does not do not comply with the conditions granted or violate any of the conditions. Dispose the. Yes, Mr. Athavan.
Can I take it?
Yes.
Item number 27, my lord.
Come, no problem. We can sit and finish this list. Yes. Now, item number?
27, 23,
Huh?
23, 23.
Please.
23. 23.
Other side is here.
Yes.
Yes, Mr. Mo.
Yes. You are petitioner.
Yes, ma'am.
Major.
You want to file an edit?
No, we have already filed, my lord. We are filing today.
Okay.
That will be completed.
26. Where the other case is fixed on?
16.
16.
Can be fixed.
Issue, my lord, here, my lord, I'm just pinpointing his.
We'll just simply say that list
Not-
this matter
Ah,
16.
Yes.
As agreed to by the learned counsel for the parties, list this matter on 16. In as much as it is submitted that an affidavit in opposition is being filed, additional affidavit, no,
Affidavit in opposition.
affidavit in opposition is being filed by the respondents during the course of the day. That's all?
Yes.
Okay.
I'm grateful.
All right.
Anybody want to go home after lunch?
My lord, item 7.
7 will, if we have to dictate this, it will take some time. So your turn is other second half or maybe tomorrow? It's up to you.
Second half.
Second half, okay. Anybody who want to go home? No. So we'll come back at 2. How many matters left? 28, 29, 30. Hearing, but I am telling you, hearing may not be possible. Who are in hearing? Mr. I will take up your matter. Saikya, I will take up your matter. Others hearing may not be possible.
Can this matter be fixed on 15?
When?
15.
15.
Interim
Interim order, continue the next date of list. Yes. Yes.
No, item number 6, my lord. The matter has come for admission. It requires some time, and I have been told that lordship is not going to take up the hearing.
No, we are not taking up hearing, but others we are taking up. You want some time?
I need some time.
Okay.
Item number 6, interim.
Yes, who is for the other side?
Yes.
When?
On 16th of June, my lord.
16th of June.
And item number, interim order is there, item number 6.
Interim order passes till next.
And 24, my lord. Lordship may kindly fix them on 16.
16.
And 25, there is an interim order 16.
No, 24, there is the order matters. Why this listed for orders will have see?
Because notice is yet to be served.
Item
number 24, notice is yet to be served.
Okay, we'll see. We'll see.
Item number 28, my lord. Hearing matter, my lord. On 19, my lord.
19.
Yes,
Okay, today time may not permit. That's why.
Yes, sir.
Yes.
19th of May.
Obligation. Yes.
I'm appearing on behalf of Mr. S.K. Diori. I'm leading by, although I'm not on record, but I am instructed by S.K. Diori.
See, we'll have to fix the schedule. That's all.
Yes. Yes, sir.
Some summons are to be issued and all. So we'll have to formalize the proceeding today. Okay.
My lord. My lord.
What is the last order?
Last order, record was called from the office of the Deputy Commissioner, Your Honor. So if record arrives, then the matter may be fixed for cross-examination of the plaintiff witness.
Okay, now tell us, you have filed IA
Already
for
filed,
record, for record.
Yeah.
Okay. What are these records?
Record is affidavit, evidence, and
Now, which are the records? No, you file an IA, is not it?
Yeah,
For summoning witnesses and calling of records,
yeah, my lord.
is not it?
Yeah, my lord. Page number 22, 23.
Page
Summon
number
22, 23 for summon.
22 or 14.
Yeah, my lord. 12 to 14, 12, 14 is record, list of records.
So you want to call record A, exhibit A.
My lord.
Please verify, because once we call again, it will be difficult. Exhibit A, that is notification
My lord,
20/03/2024.
my lord,
Then exhibit B,
E,
2/6/2024.
my lord,
Then exhibit E,
E, C, A, B, C, E.
copy of news broadcast dated. How can you bring it? It is cannot be from the deputy commissioner.
This is my representation that I have during the time of scrutiny. that
No,
I
copy of the news. Where do you exhibit A, B, E, F, G, H, I, and J? You'll have to give a specific list of this.
Oh, copy of, no, just I have given this, but I don't want to seek, I don't want to seek this. Yeah, exhibit C that I don't want to seek.
These are your exhibits.
Yeah,
Which document you want from and from whom? That is, we'll have to call. We'll have to ask that party that these are document in your possession. Please give it to produce it.
my lord, this all has been given in exhibit, detail is given in exhibit, page number 22 to 23. Someone and
Page number
the to whom someone is to be issued.
of the IA.
Yeah, my lord.
Page number
22 to 23. And list of documents which to be seek from the RO, the CEO.
is not the way. You'll have to give details. See, at page 25, is not it?
22, 23.
22 is the form of summon.
Yeah, my lord.
Is that it?
Yeah.
Form on summon will have to give the details. Which document you want to be produced.
So for that, my lord.
Where is that?
Serial number 4.
Serial number 4 of page
List of
22.
documents 12 to 14.
Page 22.
No, serial number 4, list of documents, page number 12 to 14.
Page number.
I.
You just tell it which documents you want, A, B, all these documents.
Yeah.
Now news broadcast dated 27/3/20 of Arun Bhumi News Channel. Now, how will Deputy Commissioner will give it to you?
This is just, my lord, I have listed this, but I don't want to mention.
But from where do I know? Oral submission will not, you must be specific that these are the documents not in my possession.
Yeah.
And this is in possession of so and so.
Yeah, my lord.
Please call the following list of documents from so and so.
Yeah. Now all documents is to be seek from RO. Rest only this.
No. Please tell us copy of news broadcast. How can you call for RO?
No, except this.
Where do you get it? You must be specific.
Then except this, what I'm saying is except final serial number 3. The rest is with RO and CEO.
This is the difficulty. It's an election petition proceeding. We cannot do like this. You take a lawyer. Otherwise, you will have to dismiss your petition. I am very lenient in this case. See, there are procedures where there must be a statement that this document is not in my possession. It is in possession of so and so, so and so, so and so. Even we can call it from the Orun Bhumi news channel that please produce the original of broadcast dated 27/3/2024. Now, which broadcast? They might have hundreds of broadcasts on 27/3/2024.
For this specific exact, that has been given in my affidavit also.
No, affidavit
During the
will
time
not
of
do.
campaign.
Affidavit will not do. You will have to give specific that I want this document from so and so. This document from so and so, so and so. Suppose you want 5 documents from the returning officer.
Yeah.
You write it down that these following are documents I require from the returning officer. So and so documents we want from the Orun Bhumi. So and so documents I want from so and so, so and so. If we think that these are necessary documents, we'll allow it.
My lord.
Okay, suppose you want to produce an original newspaper.
Yeah.
Okay,
Yeah.
we may not permit you, but you can get it in the market, the original newspaper.
Exactly.
Isn't it? So
My
it
lord.
cannot be an application like you file a fresh application.
Give me some time for filing the fresh application.
Learned, no, see, you consult some lawyer.
Exactly.
Otherwise, we'll have to, otherwise this is a, I have to be dismissed and straightway say this is not informal. It's an election petition, not a writ petition that we go beyond certain limit.
My lord.
The learned counsel, the election petitioner in person submits that though he has filed an application, praying for summoning of official witnesses and production of document. However, such application is not clear and specific as regards which documents are required for whom. He has only marked as exhibit A, B, etc. Therefore, he may be allowed to withdraw this application with a liberty to file an appropriate application clarifying which are the documents from whom he want to rely on and not in possession or not in his possession. And secondly, he will full stop. Accordingly, the present application stands allowed with liberty to the applicant to file a fresh IA.
May I, my lord, did exhibit and all these things already submitted? This
That we understand. You have already submitted.
Yeah.
Moment the witness will come, you will have to prove this is onus is upon you to prove it.
Yeah, my lord.
Isn't it?
Yeah.
So who will prove it? I'm not here to teach you what is election petition is.
Yeah.
I'm
Yeah.
here to decide. So I'm asking you one and again, if you are not well conversant with this procedure, please get yourself well conversant or engage in counsel. We cannot waste time. An election petition is to be completed within 6 months. We are already more than 6 months. This is not the way. See, certain things you have filed evidence in IA, evidence in affidavit. We have just ignored it. It is not the way. Until and unless you are given a specific date and time, then only you can file it.
My lord, this all has been filed as per suggestion of this court, honorable court. Yeah.
No, suggestion, we cannot give suggestion. Just only for the reason that a petitioner in person, we have just hinted how to do it.
Yeah.
From next time onward, we will not hint. You will have to file an application. That I have said. That you will have to file an application summoning those documents. You will have to give list of documents which are in your possession, which are not in your possession. You will have to file an application calling. I cannot write an petition for you.
Exactly. Yeah, my lord.
No, this way your election petition even will not proceed and in absence of evidence it will be dismissed. Election petition is very strict.
Exactly.
You're very strict. This is not the way. I am giving you a last chance. Please, this matter, when can you file it?
At least some suitable time may be allotted. to me.
You tell us.
Coming Monday.
No. I am giving you more time.
Okay.
Coming Monday.
19, then I will send 19 on 19.
No, don't be hurry. We are giving you 2 weeks time. Consult it, how to file it, which are your document, you do it. And henceforth, I will not have any discussion or any observation in this case. We'll
Obliged.
proceed as per law.
Obliged.
Again, list it again on. After 2 weeks, give a date. Good that they have not objected to your petition. In election petition, every application is opposed. They have not opposed it. Yes, the learned counsel for the returned candidate has not objected to such withdrawal. Okay. All are same both brothers. Yes. Next case.
Lordship, in terms of order dated 4/4/25, the petitioner has taken fresh steps upon respondent number 8.
Okay. The petitioner has taken fresh steps on 8/4/2025. Await service report and list this matter after 2 weeks with an updated service report.
Yes. In the meantime, Lordship,
Interim order, pass or shall continue till the next date of listing. Deeply audited. Yes, Mr. Prakash, what you want to say?
My lord, amicus curiae was appointed on behalf of private respondent. So matter is otherwise.
Appointed?
Yes, Your Lordship, Mr.
Okay.
Tama. Your Lordship, in this matter, we'll be needing the scanned copy of the TCR, Your Lordship, otherwise.
TCR?
Yes.
Okay. It is seen that Mr. M.S. Tama has been appointed as the legal aid counsel to assist for the respondent number 2, full stop. It is submitted by all the counsels at the bar that scanned copies of the TCR may be necessary for proper appreciation of the case. Accordingly, in the considered opinion of this court, TCR shall be required. Accordingly, registry to call for the scanned copies of TCR of which case?
Corresponding to WPS case number 3 of
corresponding to session. What is the session case number?
GR case number is 4 of 2021.
GR case number 4 of 2021. Corresponding to Tezu police case number 03/2021 under section 498A/506 IPC. What is the ground?
Ground, my lord, there are 4 affairs. So, my lord, last affair is hit by section 162.
So, Lord, all the 4 affairs be taken up together and proceed against you. What more is required?
Because, my lord, same allegation, in all the cases, same allegation.
All are treated to be 161 statement, that's all, at different stages.
The next statement, lord, should consider. Next statement, lord, should be considered.
It is the only issue when you say somebody remains somewhere, but that is no more no more an issue. Supreme Court has decided the wife can file 498 application where from where she has taken shelter without beyond the jurisdiction.
Yes.
Even then, my lord.
5 minutes to dictate. Yes, next case.
My lord, this is an, my lord's item in respect to which there is a stay order.
Item number 25.
And private respondent notice was served. I don't know, my lord, today whether they are going to appear.
Anybody appears for the private respondent?
Your Lordship, I've been informed that they will appear, Your Lordship, but I don't think they appear today.
Okay. Service is complete?
Yes, my lord.
It is,
Because they are going to appear, and I am being told that somebody is going to appear today.
okay. List this matter again on, what is your date?
16 months.
16th.
An interim order.
Interim order passed earlier shall continue till then. Earlier also 16th.
Earlier, no interim order.
Huh? No, earlier no interim order. 16 June.
June.
Obliged, man.
Maybe your lordship.
26.
This is a appeal against conviction, lordship, and along with that, we have filed the application for bail. Your lordship may kindly.
What about the service upon respondent number 2?
Lordship, we are appearing, Lordship. I am appearing.
You are appearing.
Lordship.
Where is the IA?
Yes, your lordship. The IA is.
IA objection file?
No.
This is under
POXO. But then lordship, ultimately.
Rupees 50,000. Full stop. Mr. Sharma, learned counsel contends that the foundational fact of age of the victim was not proved by the prosecution, and therefore, on the said ground, the entire prosecution against the petitioner under POXO Act is liable to fail. On the other hand, he further contests that the deposition of the victim clearly shows that.
Oblige your lordship.
Hey, hello. Yes, what is this?
My lord, this is quashing petition.
Hmm?
Quashing petition regarding a FIR lodged for the Parliament Police Station, alleging of tape and the demolition damage of the public property.
Scan copies of the case diary.
Yes, Lordship, we have received.
My lord, in the meantime, the authority concerned has issued one clarification letter saying that authority has not lodged any FIR before the police regarding this DJM scheme, which is executed in my village.
Now, who lost this case? Palin Police Station case 2024. This was.
The complaint was lodged by one Yura Kaha and 8 others. FIR is on page 15, Lordship, in the petition.
This should have been come in motion, is not it?
No, no, Lordship. Last time, Lordship, it was in motion, but court had directed me to produce the
Therefore,
scan
this
copy of the
notice
case.
is not yet issued. Yes, please show us.
Yes,
the
Lordship.
first. What is the material in the case diary?
Lordship, a charge sheet, already charge sheeted, Lordship, and in the charge sheet, Lordship, they have found that, Lordship, this person, Lordship, this accused person, Lordship.
Heard, Mr. Torun.
Yes, Peter.
And so learned additional public prosecutor. Pursuant to discourse order dated 34/2025, MS Swensuk has produced the case diary. However, submitted that in the meantime, the investigating officer has filed a charge sheet, being charge sheet number. Any charge sheet number has filed charge sheet, isn't it?
Number is not there, Lordship.
Huh?
Number is not there.
And close this is for after subbing, being charge sheet, right? Palin PS charge sheet number 03/2025 dated 19/3/2025 under section 303 BNS read with section 3 of the PDPP Act Now, before which court? CGM Palin?
Yes, Lordship, CGM Palin.
Palin. Full stop. Registry to call for the scanned copies of the
JMFC Palin, Lordship.
scan before full stop. There's registry to call for the scan copies of the. Where is the GR case? Something should be there. There must be a GR case.
Yes, GR case.
Please go to
Yes, sir.
registry to call for the scan copies of the record of GR case number.
Lordship, that is not given here, Lordship.
Can you have our telephone?
Lordship, oh, I'll have the.
So I'll keep the gap.
Yes, Lordship.
Okay, GR case number so and so, in connection with Palin PS case, police station case number so and so, so and so.
Palin KPS number 22 of 2024.
2024, including the case diary.
Lordship.
You can take it back because case diary will come in the record.
In case I can retain here, Lordship.
Okay,
Case
you
diary,
retain
Lordship.
it,
Yes, Lordship.
okay. Along with the case diary. Issue notice. ऊपर पे लिखिए issue notice. You just take first paragraph, then second paragraph of this, then this is thereafter issue notice, so and so, so and so. So and so accepts notice on behalf of the any private respondent, no. Okay, accept notice, no formal notice, extra copies. Okay, and then registry to call for the so and so.
Offline, Lordship.
And list this matter after 3 weeks.
Offline.
List this matter after. Yes.
28.
28.
Yes, ma'am.
Not today.
But it is a very simple issue, ma'am.
Oh,
Undisputed.
this is a first appeal. Do you know
Yes, ma'am.
how first appeal judgment is to be written? By a judge. What is the provision in the CPC? How a decision is to be taken by first appellate court in a first appeal?
One of the steps are complete, ma'am.
Steps are completely understood. Matter is fixed for hearing.
Yes, ma'am.
We'll have to hear it and take a call decision.
Yes, ma'am.
In a first appeal, we'll have to we are the last court of facts and law.
Yes, ma'am.
So we'll have to go details,
Ma'am.
own appreciation of evidence, each and every evidence.
Ma'am, no trial was concluded, ma'am. Only on the preliminary issue, my petition was dismissed, ma'am.
Maybe, but we'll have to look into why this preliminary issue. Again on.
It was already actually I have mentioned, ma'am. At 2, ma'am, I have already mentioned, ma'am. On 19, ma'am.
19?
Yes, I have already mentioned, ma'am.
Okay, you have already mentioned.
Yes, at 2, yes. At 2 p.m. I have mentioned.
Okay. On 19. Okay, she missed it. On 19. Okay. Now, Mr. We'll take first another matter is there. We'll take the 7.
Yes, my lord, at a glance, I have said that one of prosecution section. But if petition and the impugned order is seen, my lord, complete non-application of mine. Even this section that Panchayat Raj Act 243, which it was invoked. I mean to say, my lord, there is no any nexus in between the action of this Gram Panchayat chairperson and other accused person.
What is the order of cognizance?
My lord, I have marked it, your lordship. Yes, that one. That one. Second one, yes, your lordship. Cognizance that aspect was not considered by the learned court below. Now, your lordship, one issue here is 197. If 197 comes, there is a slight distinction between section 19 of the PC Act and 197.
No, I'm not on 19
Yes.
of the
Now,
PC Act.
now when 197 comes, if it is not been taken into consideration, this expect at the cognizance stage, and later on, if it comes, and even if your lordship during the consideration of charges, during a framing of charge, even without sanction, if court feel that it is not nexus, it has no any nexus with the duty, then court can proceed further. But during the trial also, if court find that it has a nexus with the duty, then at this
So
stage,
you want to say this is not a sine qua non. It is, if it is under section 196,
yes, your lordship.
it would have been different.
Yes,
It
your
is under 197.
Seven.
196 or 19 of the PCA.
PCA Act, yes, absolutely.
PCA, forget about 196 also. Please see 196. Because it starts with no court shall take any cognizance
Yes, your lordship.
of any offense under section 196. I was under the impression of 196.
Yes, prosecution
Yes.
for offense against state for criminal conspiracy and for criminal conspiracy to commit such offense. It is same like section 19 of the PCA Act, your lordship. Yes.
This is 196.
Yes, your lordship.
Please read 197.
When any person who is or was a judge or magistrate or a public servant not removable from his office save by or with the sanction of the
Mr.
government.
Tama, if we go into the merit, whether this discharge is correct or not, or whether there are prima facie material, it will take some time.
Sometimes.
That I will not do today.
Yes.
My lord.
He's I think he's correct. I was under impression of 196.
Yes, your lordship.
In fact, I have asked them to, just now I have asked them to bring a judgment.
Yes, your lordship.
So far, when it starts as no court shall take cognizance,
My lord.
then it will be different.
Yes.
This is applicable in case of 196
Six.
and some specific offenses.
Yes, yes.
At that point of time, while we are hearing, my mind was not to 197 to 196.
No.
But beyond that, he can hesitate that this discharge is wrong because these are the prima facie materials.
My lord. Therefore, I am saying.
So forget about the sanction. Sanction is not the only point.
My lord.
Now, if we hold also that there is no requirement of sanction, it can proceed. His second contention's argument would be that those materials where prima facie can, on the basis of it, a charge ought to have been framed.
Correct, my lord.
Ought to have been framed, and therefore, because at the framing of charges, suspicion is sufficient.
My lord.
Not even grave suspicion is required.
My lord. Here in this case, my lord, what happened?
So,
Even
Mr.
the learned
Tama,
royal
I have kept you waiting, but not today.
My lord.
That part is not today. You also come prepared. Okay.
I have done extensive research.
Tomorrow in that case, my lord.
Tomorrow may not be possible. See, I'm to be frank. Switch off that. Where is your note, written note? Chronology
Lordship,
of-
before my learned friend
Okay.
starts his argument, there is a latest development that has taken place, Lordship. When this entire matter was heard, was pending before the learned court below in the first
Some length. The learned counsel for the respondent has produced a communication, minutes of meeting dated 2nd of May 2025, suggesting that there is a initiation of compromise between the parties. However, Mr. Saikia, learned counsel for the appellant, submits that till now, he has the instruction to submit that there is no scope of compromise. However, since he has produced a record, he will complete his instruction as regards the minutes of meeting dated 22nd of May 2024. Be that as it may, a serious allegations of judicial impropriety has been raised in the IA civil number 149/2024. Since in the meantime, the same will be taken on the next date fixed. Please this matter on
30th June.
You'll have to be in virtually 38th of June.
30 and 30 June.
30?
June.
Not June, keep it in May.
No, because
30th of June. Okay, 30th of June, fine. Fine. Maybe we'll have to, maybe here or maybe.
Lordship, I'll appear if Lordship is not here, I'll appear to virtually.
Okay. as part order. 3-0.
Obliged.
That's why I wanted your note. And he has already filed an affidavit. I've gone through it. His stand was that everything was regularized by virtue of the order. Now, whether that is permissible, if permissible, how permissible,
order
we
is-
understand, we understand.
Clear admission of that.
Not clear admission, Lordship, whatever has
Lord,
been done, it was done out of good, this thing.
Maybe this is the tip of the iceberg. Man.
That is why we are keeping it as a part order.
Lordship.
And what the problem we are facing after that is, my colleague, the certified copy were not given immediately nowadays. So they become cautious. That is causing more
No,
trouble.
that should be. Because this is sacrosanct.
Yes.
An order of a court is a sacrosanct. This cannot be changed like.
This
in
is
that
not good
manner.
for institution also.
Yes. Suppose I do something in the chamber, correct something and a person of the order day after tomorrow, it will not be. If I want to correct that, I will see. Yesterday, I directed a method to be listed tomorrow for delivery of order. In fact, my order is ready. This method is by mistake listed today. I could have said, and I have passed the delivery order, but on the earlier order matter is fixed on 8. How can I take up this matter at the date before? So I have specifically written that list this matter as fixed earlier. These are the judicial sanctity you will have to maintain it. Otherwise, I have heard it is to me, I could have passed this order. Order is ready only to sign. Why I have postponed it till tomorrow? Certain documents are sacrosanct.
Agreed.
30th of today is
7.
so it cannot be 30th of June. It cannot be then treated as part hard. It cannot go beyond a month. Today is 7th of May. You fixed it around May, last part of May.
My lord.
30th of May.
My lord, because I have got outstation cases.
Okay. So before that, you wherever you are in Guwahati, because I can tell you that I am in Guwahati till 30th of May.
Can it be on 21st of May?
21st of May. Okay. Any problem with
No,
it?
no.
You might have to appear for virtually. Okay.
Obliged.
Sorry for keeping you for a day, but sometimes it happens.